a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
We got two real good lawyers for you today. Seriously. Why have one when you can have two? Because David Whiting was away last week. Remember, Liberty Sanger joined you, partner at Maurice Blackburn. She's got a little homework to share with you. And then David Whiting is going to take your calls, as he always does, on 1300 222 774 and hopefully give you some very important legal advice. Do grab a spot on the lines right now, 1300 222 774. David, I'll get to you in a sec. Liberty Sanger, good morning.
Hi, Virginia.
You had two issues to follow up with that you took away as homework. Tell us what they are.
I did. Well, I had the question around volunteers. You might remember we were asked whether a volunteer could take any action against a bully in a workplace. And the answer is yes. They're covered under the Occupational Health and Safety Act. So if you're being bullied, you can contact WorkSafe and report the bully and ask for WorkSafe to come out. Whether or not WorkSafe does will be a question for them, but nonetheless you are covered. And we also mentioned last week that you could look to see whether there was any issue about discrimination based on the Equal Opportunity Act. So contact the Equal Opportunity Commission or the Australian Human Rights Commission. There's one other interesting thing that you might want to think about doing, which is you can apply to the Fair Work Commission for a stop bullying order. Mm-hmm. But the trick with that is that you can only do that if some of the people in the workplace are in fact workers, not volunteers. So if everyone's a volunteer, that won't apply, or the Fair Work Commission won't have jurisdiction. But if some of you are workers, then the Fair Work Commission can consider a stop bullying order, and that may be a good remedy. From a practical point of view, though, I would like to say that I think the best way through this is to work with the other people in your workplace and potentially use a grievance procedure or think about raising this up the chain, because some of those remedies I've given you, although they are there technically, they're quite hard to access, and that can often be due to limited resources of organisations.
And you also just quickly wanted to run through the attributes covered under the Equal Opportunity Act?
That's right. So if you wanted to look at the equal opportunity remedies, if you have been discriminated against on the basis of your age, your parental status or your carer status, of a disability, your employment activity, your gender identity, your industrial activity, your marital status, your physical features, your political beliefs, pregnancy, breastfeeding, race, religion, sex, or your association with someone who has any of these characteristics, then that will enliven the jurisdiction of the Equal Opportunity Commission. In plain speak, that means they can hear what you've got to talk about, and they can then try and mediate to come up with a solution for your problem.
All right. Thank you for that. And I know we'll get you back again soon when David needs to take a furlough. It'll be great to have you on board, Liberty. Thank you for that.
No worries. Thank you.
Liberty Sanger there, partner at Maurice Blackburn. David Whiting taking your calls, 1300 222 774. David, good morning.
Good morning.
Got a crackly line there. See if we can get that a little better. Let me just explain again in case you're surprised to hear that everything sounds a bit different. Because of COVID-19, we have a strict policy about who cannot come into the studio, and no one can come into the studio at the moment. No one at all, just those of us who are broadcasting. So, David, you're talking to us from where? What secret location are you?
Queen Street, Melbourne.
Sorry, David? Nah, David, it's not working. Tell you what we're going to do. We're going to just call you back. We'll get you on the line and we'll see if we can fix it that way, because there's no point having a long segment with David if we can't actually get that line fixed. So the moment he's back on deck, we'll put into air for you. The number, if you have a question for David Whiting, is 1300 222 774. Lots of comments coming in on text, though, and I haven't had a moment to get to those, so let's get through a few. Hi. Oh, here's a question for David. We'll see if we get to that one. But you know the rule. You're not allowed to text in with your questions for David. You've got to actually phone in. But this from our issue about city shoppers going and clearing out the supermarkets in regional towns. Hi. Ask shoppers in regional towns to produce a driver's licence or another ID which has a residential address before processing their groceries. Woolies, Coles, IGA, do you like that idea? I do. I think that sounds great. David, have we got you on board there?
I'm here.
There you go. We can hear you now. So let's get to we've got some homework for me, first of all, quickly.
I did. I have Dallin. Dallin called from Albert Park a couple of weeks ago, and Dallin's query was in relation to a family member who had been the subject of family violence, and there'd been a community corrections order.
Mm-hmm.
And Dylan's question was that there had been that the accused person who got the community corrections order had also been convicted of aggravated burglary. And he didn't think you could get a community corrections order if you were convicted of aggravated burglary.
Yeah.
Well, that's not you. A community corrections order is an inappropriate penalty for aggravated burglary, and aggravated home invasion requires a custodial sentence. But if your record includes aggravated burglary or aggravated home invasion, you're not prevented from getting a community corrections order on another matter.
Okay.
All right? So it all depends on the way you ask the question, but the way he asked it was he's been convicted of a family matter,
Mm-hmm.
and he's got a community corrections order. Yes, that's fine.
Okay. Also, you wanted to make an observation about the state of emergency that's been declared?
Yes, because it's always interesting to me who makes the statements of the declarations of emergency and what effect they are. And we have a piece of legislation called the Public Health and Wellbeing Act, which says that the state can declare a state of emergency. The maximum period of declaration is 4 weeks at a time, and the maximum number of, the emergency with the current legislation can't extend beyond 6 months. So there's a provision in that Act, the Section 199, that allows people, allows authorised officers, if there is a issue in relation to your being out and about, there can be a fine of $19,800. You can be locked up. In the case of a body corporate breach of the regulations, can get you a fine of $99,000.
Wow.
Yeah.
Oh, yeah, okay, that's big money just for the price of wandering around. Let's get some questions answered, 1300 222 774. And Harpreet has called in from Mernda. Good morning.
Good morning, Virginia. Good to talk to you.
Go ahead.
David, my question is if the lockdown happens in the coming weeks, how would the parenting order will be impacted? Will the kids miss out a time with another parent?
Well, let's look at it from 2 points of view. If the parent who wants to exercise access has is affected by the virus, I would have thought that they should give up their contact during that period if possible. And from the point of view of would I allow a child to go to someone who is infected, I think the answer to that would be no, and I can't see that a court would take you to task for doing otherwise.
Yes,
right? So you need to be. So you might be technically in breach of a court order, but I just don't see the court would sanction you in those circumstances. But just make sure you're absolutely right, whatever decision you make.
Harpreet, if someone keeps the children with them because of the lockdown, would there be a big quarrel between the two parties, do you think?
Sorry, what did you say? Sorry.
That's all right, Harpreet. I think you've got your answer, so we might just leave it there and we'll move on. Mary has called in from Melbourne. Hi, Mary.
Hi, Virginia.
Go ahead.
My question is, my daughter was involved in a car accident, which was probably most likely her fault. But we've received a letter from a debt collection agency seeking reimbursement for the damages done to the other car. But we have some concerns because we've seen photos of the damages and it's not actually, they don't look to be related to the accident. They're actually on the other side of the car. So we're wondering, should we be going through our insurance company to handle this, or is there some other way that we should, I guess, question the damages and the reimbursement that they're seeking?
How much are we talking about, Mary?
$2,700.
Right, and what's the excess on the insurance policy?
It's about $2,000.
So we're awfully close to the same number, aren't we?
Yep.
Okay. Mary, what I would suggest you do is ask the insurance company or the debt collector that set the letter of demand and ask them for a copy of the assessor's report. Now, before the repairer will have fixed the car, there will have been an assessor sent out by the insurer, and the assessor will have prepared a report as to the work that's required for the car.
Okay.
Now, there's obligations under something called the Civil Procedure Act, which you would bind the insurance company. You've got to try and resolve these things before issuing, and so that's where I would start. You want a copy of the assessor's report because you think that part of the damage claimed isn't related to the incident.
And should their insurance company have that, or would it be the debt collection agency, or should we try both?
Well, I would try both.
Yep.
I don't expect that the debt collector will have it. What the debt collector will have is your daughter's name, the date of the accident, and an amount of money.
Yep.
And lots of debt collection agencies actually provide their letter templates to their customers. So it's possible that the first letter from the debt collector didn't come from the debt collector, but from someone who filled out a form online.
Right, okay. No, that's great. Thank you.
Good luck.
Pleasure.
Thanks a lot.
Good on you. Gary's called in from Winchelsea with a particularly interesting problem. Hi, Gary.
Hi, Virginia.
Hi, go ahead.
Thank you. I've got a hobby farm just out of Winchelsea. I actually rent the place out, and there's a gravel road goes up the side, and apparently about a month ago now, there was a fella herding some sheep up the side road, and a couple of them got into our place. He couldn't catch them, so he's locked them in there. They've been there for a month. I've tried ringing around the neighbours, anyone I could think who might own them. I can't find the owner of them. I'm just wondering what the legality is. Like, what do I do about them? Can I keep them, or are we going to be in strike if someone pulls up later on? Or?
I don't know. Look, you can tell I'm a city boy, Gary. What's a sheep worth?
Well, they're pretty healthy-looking lambs. The lamb market's pretty good at the moment, so $150, $200 each.
There are provisions in the Australian Consumer Law and Fair Trading Act that talk about the disposal of unclaimed goods. What I would do is I would ring the pound to the council and ask them to come and pick them up.
Yeah, I don't really want to do that, though, because I'll miss out then. I'm not going to get any sort of replacement feed for the feed.
Have they've been eating feed on the property, have they?
Well, that's right. Yeah, I run a few beef cattle, and I've only got 4 other sheep of my own, but they've jumped in with those and they're hanging out with those. They've been there for a month, so they've eaten a month's worth of feed, so I would have thought I'd at least do a roll of hay, or I'll cut their throat, put them in the freezer, one or the other.
Or entitled to claim them. No one's coming back to claim them. No one's come by and said they're my sheep.
No, that's right. And I've rung around trying to find the owner, and I can't find anyone who owns them. So I don't know what to do with them.
David?
Disposal of unclaimed goods in the Australian Consumer Law and Fair Trading Act. Basically, the problem will be is to turn them into dinner, no, but you could sell them, and then if somebody turns up, you've got to account to them for the money.
Okay. All right. Thank you very much.
Thank you, Gary.
Thanks for that. How long, under that legislation, David, how long does something need to have been left before you can claim?
Well, I don't know that you could ever claim it as your own.
Right.
There's a concept of disposal of unclaimed goods. They're on your property, they belong to somebody else, and what you're allowed to do depends upon the value of the item. If I left a Picasso, then that would be, there's a long process I need to go through, but if I left a ballpoint pen, it's a very short process.
Hey, what if Gary sheared them or shore them, if that's the right word?
They're lambs.
Oh, they're lambs, yes. They're not going to be quite woolly enough yet.
No.
Just thinking on the fly here.
Okay.
Emily from Dalesford, beautiful part of the world. Hi, Emily.
Hi, how are you going?
Good, thanks.
My question relates to, I work as a trainer and a facilitator, and got a job with a company who I did some training for. They paid me once, and now I have outstanding invoices from 6 months ago that they haven't paid. Of course, I've tried.
How much do they owe you, Emily?
It's only $1,700.
You could sue them in the magistrates' court, is what you would normally. Oh, so you could actually take them to VCAT. You provided a service, you're entitled to be paid. VCAT is a jurisdiction where you would turn up, and what you'd be up for would be the application fee, but you wouldn't be paying lawyers. You get a judgment at VCAT, you can register it in the magistrates' court and enforce that.
He's actually in Perth. I think the company's based in Perth,
Where did you provide the services, Emily?
Melbourne,
Then you're entitled to go to VCAT.
in Melbourne.
Yes.
Okay, so just
So
hop on the website and follow.
vcat.vic.gov.au. You can fill it all in online. You can pay the fee online. I would, as a matter of courtesy, write to the firm in Perth that's not paying you and tell them that's what you're going to do, and you'll end up with a judgment in Victoria
Okay, then.
that you
Thank
can
you very
you
much.
can enforce anywhere.
Okay, terrific. Thank you.
Good on you.
Bye-bye.
Well done. Hayden's called in from Parkville. Good morning, Hayden.
Good morning, Virginia. Good morning, David.
Good morning.
I'm wondering if you can help me with an issue. It's finally been resolved without needing legal action, but I moved out of a place in November. I was sharing with another tenant, and to get me off the lease to remove my liability, it took 4 months. VCAT said, because I meant to decide to take legal action, but VCAT wouldn't hear it. The Community Legal Centre didn't want to hear about it. There appeared to be no way for me to take legal action between two tenants.
So you share with somebody else, and
I did.
And so you both signed the lease at the start.
I signed the lease later on moving in because she was a continuing tenant.
Right, so there was a transfer and you took over
Yes.
part of the lease.
And then we both agreed. And then I said I wanted to move. She agreed with that, so I stopped paying I was paying her and she was paying the landlord. We were both on the lease.
Yes.
So the rent, it wasn't an issue of rent. It was an issue of the fact that while I'm on the lease, I'm still legally liable.
Yes.
And she was dragging her feet on the paperwork. In the end, it took 4 months to get it signed after I'd moved out. So I before that, I decided to try and take legal action. I still haven't got my bond back, my half of the bond back, actually. But VCAT said they won't hear it unless it's between landlord and tenant. The Community Legal Centre said they can't help because it's not between the landlord and the tenant. And there seems to be nowhere you can go if you have a dispute between two tenants. There doesn't appear to be any legal avenue I could find.
David?
There is. Well, it's a contract dispute between you and your co-tenant. You've got an agreement, and you want to bring it to an end.
Yes.
Therein lies the problem.
So where
would
do
you
I
go?
go?
Well,
I have we had an argument, and I have evidence of her pretty much instructing me to move out.
There's
I said I
short
agree.
answer. Hayden, I'll take it on notice, but where I'm thinking is that it would be a dispute that you would take the matter to VCAT with a request that the lease be terminated.
I did.
No,
And I said it's not between landlord and
you're
tenant.
going to VCAT in an action against the landlord that you want to bring the lease to an end because of changed circumstances.
But I'm not the only tenant.
I understand. So you make that tenant a party to the proceeding as well. So at the moment you've got an agreement with a landlord on one side and two tenants on the other, and you are now saying, I want to bring the whole thing to an end.
So what I would do is make the action between the landlord or the other agent and the tenant and myself rather than just myself and the other tenant.
Yes.
And then VCAT would hear it.
Then VCAT can hear it. There's no obligation on them to give you what you want, but it's an application.
Okay.
But you're there and you're forcing people to talk.
Okay. Thank you very much.
Good on you. So it's a change in the triangulation between the partners in dispute and the way you actually see that.
You're forcing yourself into the jurisdiction of the tribunal.
Yeah, okay. Which is a very clever idea. Sam has called in from Ivanhoe. Hello, Sam.
Good morning. Can you hear me?
Yes.
Yeah, I've got a current intervention order matter underway. It's my second one that I've had against me from my ex-partner, and she uses these IVOs in a manner to basically keep me on my toes and attack me. And she's had them in place against previous partners and also her own children who are now teenagers. And the police are doing everything they can to try to kind of safeguard me from her kind of current claims to have me breached on these orders. But there's nothing they can do to really stop her doing it.
Well, what do you mean they're doing everything they can to safeguard you?
Yeah, so they've sort of put notes on her file, making any police aware of her previous behaviours and her
So
constant.
the police have decided that she's vexatious.
Definitely, and they've also named me as a victim of family violence. So I've subpoenaed all their material, and their notes are very, very telling of their impression of her, and they say that actually.
So, but just jump to the chase. What's your question for David?
I guess my question is, is there a way that I can try to stop her from making these attacks on me through the intervention order system? Is there any safeguards in place?
The intervention order system is clearly for the benefit of those who are oppressed or feel they're being oppressed.
Yeah.
And so the assumption will be that if you've asked for protection, you need protection.
And would that be through a counter order against her?
Well, you could issue another order. You could issue an application against her that basically says, I don't want any of these to proceed unless the court has made a preliminary finding.
Right.
But the problem will be that the court will almost always make a preliminary finding.
They do, and they need to, which is reasonable. I understand. Every application.
But when you get to a final hearing for these things, Sam, do they fall away? Does she lose them?
We've never managed to get to a final hearing. They just keep getting bumped and bumped and bumped. So they go for years through the system, getting bumped every time. So, but while that happens, there's an interim order in place, which
I understand, and for Virginia, it's a truly obnoxious. There's a process in the legislation that says these things are supposed to happen very quickly.
Yes, indeed.
But they never do. They take forever to get resolved.
Which is alarming for all parties, and particularly for those who feel unsafe.
Well, except the person who feels unsafe or who issues the application, Virginia, has the benefit of the interim order, which might last, in theory, longer than you're ever going to get a final order for.
Mm-hmm.
Yeah.
So, Sam, the answer will be you just have to make sure it runs.
Yeah, and often, like we went last week for a contested hearing, and there was no magistrate on the day, and they said come back in November. They just didn't list it on the day.
And matters will slow down even more now that court cases have pretty much stopped, haven't they? In fact, you wanted to mention that, didn't you, that jury trials have been suspended until further notice. And I think that matters have stopped in the county court and the Supreme Court, I think, David.
Matters are currently running in both courts if they've already started.
Okay.
There's a consideration as to what might otherwise happen, but they're not impaneling juries.
Okay. And that will just make a already clogged system even more run down and run to a halt.
Yeah, I think the next thing will be trying to do video conferencing.
Right.
We're certainly doing that at work.
Yep.
We've got a few people who say, don't want to come in, but can we do it online?
I think a lot of people are finding it's an interesting world working from home. I would like to check in a couple of days in with everyone about their productivity and see whether it's been good or bad working from home. That's something we need to watch and wait. David, always good to talk to you. Thank you.
Thanks, Virginia.
David Whiting has taken one matter on notice for next week, and he'll be back with you, taking your calls and providing you with free legal advice.